I am Liana, the director of Hsl Plastics Sdn Bhd.
Hi, I'm Kavisha Sivaraja, the director of Hsl Plastics Sdn Bhd.
Hello, my name is Muhammad Daniel Dean bin Darsham and I am the company secretary of Hsl Plastics Sdn Bhd.
Hi, my name is Muhammad Azmin bin Abdulaziz. I am the Chief Internal Auditor of Hsl Plastics Sdn Bhd and also I am the video editor in this group.
Hello, my name is Muhammad Adli bin Yusuf. I am the Chief Executive Officer of Hsl Sdn Bhd and also one of the video editor.
Hi, my name is Nur Aina Azrin binti Zaina Rashid and I am the Chief Operating Officer of Hsl Plastics Sdn Bhd.
Hi, I'm Hui Hong. I'm the Chief Legal Officer and I'm also the narrator in this video.
Hi, my name is Nur Afina. My position in this company is as Chief Financial Officer.
My name is Keshika Ganesan and I am the Chief Marketing Officer.
Hello, my name is Fatin Nadia binti Jalani and I'm the Chief Human Resources Officer in Hsl Plastics Sdn Bhd.
Hello everyone, my name is Izatul Masana Semiti Nasruddin with metric number 200243. I am the Chief Information Officer of Hsl Plastic and also a director for this video.
Hsl Plastics has been incorporated since 2013, but there are unexpected problems that arose between the directors of Hsl Plastics Sdn Bhd that started on the year of 2015.
The plaintiff is Tan Keng Meng and there are three defendants which are Hsl Plastics Sdn Bhd, Lim Shen Li and Lim Kai Ming. The plaintiff seeks relief under Section 198, 199, 213 and 346 Companies Act 2016 that the second and third defendants oppress and disregard his interest as a minority shareholder by passing a resolution to remove him as a director of Hsl Plastic and reappointing third defendant as director when third defendant had been adjudged to breach his fiduciary duties. Both plaintiff and second defendant own 35% shares in Hsl Plastic, while third defendant owns 30% shares in the company. Hsl Plastic is incorporated when the plaintiff and the second defendant are invited by third defendant. In May 2015, the plaintiff offered to purchase third defendant shares in Hsl Plastic. Third defendant proposed to sell based on the company's audit. 4 months later, the third defendant was forcibly expelled from the premises of the first defendant by the plaintiff's brother. Then, the plaintiff, without the approval and knowledge of the second and third defendants, and without the board of directors or members' resolution, sold all the assets of the Hsl Plastic to Hsl and TNL. In October, a meeting was held between third defendant and the plaintiff. Hsl would purchase third defendant shares in Hsl Plastic and the plaintiff buy diagram of the CAD mode by KM Extrusion. In November, third defendant set up KM Plastic and resigned from Hsl Plastic 1 month later.
On March 2017, Hsl Plastics, Hsl and TNL initiated proceedings against third defendant and KM Plastics for intellectual property suit as of copyright infringement, industrial design infringement, and breach of fiduciary duties for setting up KM Plastic, which is a competing company. Then, on July 2017, sale of the second defendant shares to the plaintiff did not materialize, causing the relationship to deteriorate and legal suits were filed against each other. Coming to the year of 2018, on 5th September 2018, Justice K.K. Wong delivered a decision in the IP suit which stated that the third defendant is in breach of his fiduciary duty as director of Hsl Plastics. The third defendant and KM Plastics then appealed to the Court of Appeal against the said decision. Then, on 24th October 2018, the second and third defendants intended to hold a general meeting to remove the plaintiff as the director of Hsl Plastics and reappointed the third defendant as director. Plaintiff has objected to the decision as the third defendant has been adjudged to the breach of his fiduciary duty in Hsl Plastics. Then, on 7th December 2018, the third defendant was reappointed and the plaintiff was removed from Hsl Plastics due to the majority member's decision. Following that, the second and third defendants wrote on behalf of the first defendant to Messrs. Josephine L.K. Chow and Co., who were the solicitors on record for the plaintiff and the first defendant in the IP suit, and instructed the latter to cease acting for the first defendant for the ongoing proceeding in the IP suit and in the Court of Appeal, as their appointment was without the approval of the board. On 24th December 2018, Hsl Chin Tieng was appointed as the director of Hsl Plastics and the third defendant resigned from the Hsl Plastics. Finally, in the year of 2019, on 4th January, the plaintiff has filed application to remove second defendants from Hsl Plastics and cancel the resolution of removing the plaintiff as the director. Next, we will see the section from Companies Act that is being applied and explained in our company's Black Days Out. Firstly is Section 198, which on persons disqualified from being a director. The provision does not state that a director adjudged by a court to be in breach of fiduciary duties cannot continue to be a director. Secondly, Section 199 on the power of court to disqualify persons from acting as director or promoter. As the present suit is not instituted by the Registrar of Companies, Section 199 is also not applicable to the facts here. Thirdly, Section 213, which is on duties and responsibilities of directors. It was the plaintiff himself who did not act in good faith and in the best interest of the first defendant. The act that has been shown by the plaintiff is the plaintiff outs or removed the third defendant from Hsl Plastics, resulted in the company being inactive from September 2015. Next, the plaintiff also sold asset in Hsl Plastics to Hsl and TNL without the second and third defendant approval and resolution. In addition, asset of Hsl Plastic is still under Oryx financing at the material time, and the plaintiff has caused the Hsl Plastics to continue to pay monthly installment to Oryx. Lastly, the section that is applicable in this case is Section 346, which is on remedy in cases of an oppression. According to the plaintiff's submission, he stated that his removal as director and reappointment of the third defendant as director constitutes oppression. However, from the defendant's side, they claim that no oppression occurred as the plaintiff is the director of Hsl Plastics. This has brought us to understand the law of minority oppression. Under Section 346, it is stated that relief is available only to a member of the company who can prove oppression or disregard. The acts of oppression alleged by plaintiff here are: first is his dismissal from his position as director. Second, the appointment of the third defendant although he is adjudged to be in breach of his fiduciary duties. And the third is the attempts to discontinue the IP suit. The question for determination here is whether the plaintiff has suffered any oppression as a member. The answer is no. In conclusion of this case, the plaintiff application is dismissed with cause. The plaintiff has lost the case.
The internal conflict between the directors worsened and is brought to the court, so Hsl Plastics called all the shareholders and the top management for a meeting to collect evidence in order to counterback the first director's claim towards Hsl Plastics.
Good morning, everyone. Thank you for attending today's meeting. Without further ado, I'd like to welcome the Chief Legal Officer, Ms. Hui Hong, to start our agenda today.
I'm Hui Hong from Messrs. Lee and Lim. Today's meeting is about finding a solution for the filed suit by Tan Ken Ming towards Hsl Plastics Sdn Bhd, Ms. Kavisha and Ms. Liana. Before we start, I would like to say if any of you have any opinion and evidence to be brought up, feel free to speak, and everything that we discuss here between me and the meeting's member. So can we have our fellow directors to give a little briefing on what had happened?
Alright, thank you, Ms. Hoi Hong. In May 2015, Mr. Tan Ken Ming made an offer to purchase my shares in Hsl Plastics Sdn Bhd. So, I just proposed to sell based on the company's audit. Well, I guess that's what we usually do. However, on 23rd September 2015, without any notice, I was forcibly expelled from Hsl Plastics Sdn Bhd by Mr. Tan. As far as I'm concerned, there was no valid reason for Mr. Tan to act so. I was very dissatisfied with his act as he was the one in the first place who invited me to incorporate Hsl Plastics Sdn Bhd.
Yeah, that is totally unacceptable. Moreover, Ms. Kavisha was also not paid her director's remuneration for the service she has provided. Besides, on 30th November 2015, Mr. Tan also sold all assets of Hsl Plastics to Ho Shen Lee and TNL plastic manufacturer without the knowledge of both of us. Aren't we the directors too? Shouldn't he be asking for our opinion?
I know, right? Then who are we in the company when everything is done without our knowledge?
Yes, so to me, this clearly shows that Mr. Tan did not act in good faith and not in the best interest of Hsl Plastics. And as we can see, he expelled Ms. Kavisha from our company, and as a result, the company became inactive from September 2015. Besides that, he also sold all assets in Hsl Plastic to Hsl and TNL without Ms. Liana and Ms. Kavisha's approval and resolution. To make it worse, I checked all the assets of Hsl Plastics and turns out all of it are still under Oryx financing at the material time. So despite the sale of the forklift, Mr. Tan has got the company to continue to pay monthly installment to Oryx even though it has been sold to others. So I think as employees of Hsl Plastics, all of us can be the witness of such misconduct done by Mr. Tan. But I'm not sure if there is any act related to the irresponsible director in the Company Act and which section we could use because I'm not from law school.
Yes, it does exist and can be related under Section 213 of Companies Act, which is duties and responsibility of directors. So now we have one solid evidence to use in court.
It is also important to note that Mr. Tan sold all our assets to Hsl and TNL, in which Mr. Tan had majority shares of 51% and control of the boards of directors with his non-shareholder wives. Sounds quite greedy and selfish, huh? However, since it was done without the approval from the directors as well as without a member resolution, would the sales still be valid?
Well, in my opinion, I think the sales would be considered void by virtue of Section 223, subsection 5, and it could even attract criminal sanctions. However, it is also based on the strength of evidence we could provide and arguments from our side.
Exactly. And around October, I had no choice but to ask for help from Miss Liana to be the mid person in resolving the issue between me and Mr. Tan.
We held a meeting then when we agreed to purchase all of Miss Kavisha's shares in HSL Plastic at the price of 97,101 ringgit and 44 cents. Then Miss Kavisha proposed 50,000 ringgit to Mr. Tan as the price of the blueprint of the CAD mold, which will be used by KM Extrusion to manufacture the physical CAD mold. Well, Mr. Tan agrees to the proposed price with the condition that the blueprint of the CAD mold is being handed to him first.
Yeah, so I guess everything seemed to go smoothly. Thus, I resigned as a director in HSL Plastics Sdn Bhd around December 2016 after I set up KM Plastic a month ago. I also issued a letter of demand through my lawyers, Messrs. Quack and Partners, to HSL Plastics Sdn Bhd for the payment of my outstanding salary and allowances.
If I'm not mistaken, around March 2017, HSL Plastics Sdn Bhd, Hsl B and TNL Plastic Manufacturer filed a case against Ms. Kavisha and her recently set up company, KM Plastic, for copyright infringement, industrial design infringement, and breach of fiduciary duties for setting up KM Plastic as a competing company. Then, on 5th of September 2018, Justice K.K. Wong found that Ms. Kavisha to be in breach of her fiduciary duties as a director of HSL Plastics Sdn Bhd. However, Ms. Kavisha and her company made an appeal to the Court of Appeal against the decision. Am I right?
Absolutely right. In July 2017, I proposed to sell my shares to Mr. Tan and another shareholder of Hsl Sdn Bhd. However, the sale didn't materialize. Instead, the relationship between me and Mr. Tan turned sour to the extent that we start filing several legal suits against each other. It was rather stressful. We planned to have a meeting then. Am I right, Daniel?
Exactly. We have informed Mr. Tan through a letter dated 24th October 2018 that Ms. Liana and Ms. Kavisha wanted to have a general meeting to pass several resolutions, including the removal of Mr. Tan as the director of HSL Plastics Sdn Bhd and the reappointment of Ms. Kavisha as the director of HSL Plastics Sdn Bhd.
That was when Mr. Tan's solicitors informed us of his objection to the reappointment of Ms. Kavisha, and she has been charged on breach of fiduciary duty as the director of HSL Plastics Sdn Bhd.
In addition to that, do you remember how Mr. Tan Ken Ming was removed from being a director and we appointed Ms. Kavisha as the director?
That's right. That was somewhere around 7 December 2018, and on 24 December 2018, we have appointed Seof Chin Tieng as our director, and Ms. Kavisha has decided to resign from being a director 2 days later.
Yes, and 2 weeks later, somewhere around 4th January 2019, Mr. Tan filed the present application for an order for the removal of Ms. Liana as director and the cancellation of the resolution removing himself as a director.
Oh yeah, I resigned from the director position. Is there perhaps any chance that operation happens to Mr. Tan while all of the directors discuss it?
No, there is no such oppression used against him.
So as Mr. Azmin mentioned, I think Mr. Tan will definitely use Section 346 remedy in cases of oppression. But no worries, as it is clear from the foregoing that relief under Section 346 is available only to a member of the company who can prove oppression or disregard. The first act of oppression alleged by Mr. Tan is his dismissal from his position as director. Besides, the appointment of Ms. Kavisha as director frustrated him more, despite the fact that she was found to be in breach of her fiduciary duties. And the last one was the attempts to discontinue the IP suite. Therefore, the answer to the issue of whether Mr. Tan has suffered any oppression as a member is absolutely no.
Yes, that is right. We shall be prepared and need to make sure there is no chance for the opposite side to attack us. How about others? Do all of you have any idea to counter and be prepared for the upcoming court session?
Yeah, I think I would like to add some. For me, one of the arguments that might be brought up also by Mr. Tan in this case would be in the status of Miss Kavisha on her breach of fiduciary contract and claim that she might not be in place or qualified enough to regain back the director's position, right? Because for me also, if I did not go through and really understand the situation and law binding to it, I would also think that Miss Kavisha is not in the position to get the director position back. No offense, yeah, Miss Kavisha. So in this case, I think we can defend ourselves by using the act under section 198, if I am not mistaken, where it stated the list of person disqualified from being a director. And director who were found to have breach of fiduciary duties is not included in the list. Thus, from the law side, Ms. Kavisha is still qualified and can be appointed to continue her duties as the director.
Yes, I absolutely agree with that. As a fact, neither Ms. Liana nor Ms. Kavisha are disqualified person within the meaning of Section 198 of the Companies Act. That brings me to Section 199 of the Companies Act. It limits the power of the court to disqualify a person from acting as a director or promoter upon the application of by the Registrar of Companies. As the present suit is not instituted by the Registrar of Companies, Section 199 is also not applicable to the facts here.
Thank you everyone for sharing the evidence. I guess we have enough evidence to be brought to the court against the plaintiff. Does anyone have anything to add or any other question?
No, I think we have covered everything we need today.
Thank you for the cooperation, everyone. I will promise our greatest service in this case.
Thank you, Ms. Hui Hong, for today and everyone for greatly participating in today's meeting. Now, I'll dismiss this meeting. Thank you.
After working so hard to find the evidence and fight in the court has dismissed the plaintiff's claim and the victory goes to Hsl Plastics. So the directors have gathered all the top management to congratulate and make a post-mortem meeting.
The plaintiff application is dismissed with cause because the judge stated that Tan Ken Meng has not suffered any oppression as a member.
So I would like to take this opportunity to thank all the chiefs who greatly participated in coming up with evidence and arguments that have hugely assisted us in winning this case. Without the cooperation from all of you, we couldn't have made it. I totally appreciate your consistent support and efforts.
So, to recap back on what we discussed, we could recall that Mr. Tan has breached his duties as a director by forcibly expelling a director of the company without any prior notice, selling all the assets of the company to HSL and TNL without any knowledge from the other directors, and also leaving the company to pay monthly installments to Oryx even though all the assets has been sold to others. These surely were the main reasons that we were able to win this case. What do the others think about the decision of the court?
Yes, actually, I think we could win because it is crystal clear that the fiduciary duties are not fulfilled when the company is being conducted by Mr. Tan. It is because, as we know, Mr. Tan did not act in good faith and not for the best interest for the company, but instead he did all those unethical things for his own benefit. And it is proven set to HSL and TNL without even having a proper discussion with other shareholders of a company. He should realize that this company should be treated as a separate legal entity and it is protected by legal law. So it couldn't be treated as he wishes. Well, I'm sorry to say this, but seriously, I think that Mr. Tan lacks of a very common knowledge about company that any director should know. And I think Mr. Tan continues, Mr. Tan continues to conduct the company, there will be more problems arise. Plus, clients might lose interest or trust towards HSL Plastics because of him and this case, of course.
Yes, you are right, Mai. Is this how a director would behave? A director must exercise his power in good faith and definitely should discuss among members before making any decisions, right? But what he did was so unfair. How can he sell our company's assets just like that? His irresponsible attitude just makes me pissed off. Anyways, by this one statement, it is proven that to him as an unqualified director. Plus, he also said that the second and the third defendants' desire is to remove him to take control of the company and discontinue the IP suit and appeal. But at the end, he didn't have even any evidence to prove it. Haha. Whatever it is, the plaintiff's removal was done in good faith. Thus, the court's decision is fair enough to say that we won the plaintiff, and I'm very much satisfied and feel safe now.
Yeah, me too. I'm very satisfied with the court's decision in our favor. We managed to prove that we were on the right side and managed to gather substantial and convincing case evidence. Following that, I think we should be extra cautious while making decisions, especially in regards to our company's organizational management.
I completely agree with you, Azmin. I personally think that the leader in the company plays an important role in maintaining the company's reputation. Thus, the director as a leader in our company should think wisely before taking any action that may worsen our company's image.
When a potential buyer sees a thoughtful leader, it gives them more confidence in the company.
Yes, you are right. I'm delighted with the court's judgment favoring us, as Mr. Tan was very autocratic in running HSL Plastics Sdn Bhd, as if it was a sole proprietorship. The directorship of a company may be changed by its members at any time. An autocratic decision by Mr. Tan to remove me as the director of HSL Plastics Sdn Bhd and selling of assets without a collective agreement were indeed against the law, and it would not be able to create a positive environment in the
I had to disagree, however, you are right. I'm pleased with the court's verdict in our favor as well. We were able to demonstrate that we were on the right track by gathering extensive and convincing case material. In addition, the director must think wisely when making decisions, particularly when it comes to our company's organizational management, because it will affect the company eventually.
Yeah, I think I agree with all that have been stated by all of the chief and also like the upper organization. So, and I would really like to take this chance also like to congratulate everyone also. Yeah, great teamwork that we have here.
Very glad to have supportive members like all of you. As the quote said, associate yourself with people of good quality, for it is better to be alone than in a bad company. Thank you so much for taking your time to join this meeting to discuss the issue of a file suit between Tan Ken Meng towards Hsl Plastics Sdn Bhd.
Thank you again, everyone, for your participation. Our solid teamwork led us to win this case, and I hope we can work more often together in the future. Goodbye, everyone. You may be dismissed.
That's all from HSL Plastics Sdn Bhd company. We hope that you get to learn something from our case. That's all from us. Thank you.
Bye.
Thank you.
Thank you.